Hello, I'm attorney Lewis Haskell, and this is my brand new associate, Mary Beckham. It is traditional when I bring somebody on board the bankruptcy team that I give the lecture I'm about to give on the nature of bankruptcy and what it's all about, kind of in a broad overview of how we deal with things. It had occurred to me that one day I should record this, maybe even post it on YouTube. So, Mary, we're about to make a YouTube video. I put you under glass so I can take my mask off, if that's okay. And also, rather than face you, I'm going to face this way. And in this way, I think we have preserved um, what the governor would want me to preserve. Okay. In any event, when I was in law school, I studied the Uniform Commercial Code, as I'm sure you did too. And we clever lawyers used to call it not the UCC, but the BAW. Bank always wins. And that, of course, is the law of debtor creditor relations. Bank always wins. In a system in which the bank always wins, you have to have some kind of a pressure relief valve, something that an opportunity for people who are simply being crushed by their debt to get out from under. Otherwise, you'll have a pressure cooker that's going to explode. Otherwise, you'll have people who basically have no reason to get out of bed in the morning because their banks own them. That pressure relief valve in our system is the bankruptcy code, 11 USC. The, um, the bankruptcy code is something that's been around for a long time. I'm very proud to point out that it is in the Constitution that Congress shall make a bankruptcy code. Um, so it's something that is very fundamental. For our purposes today, we will talk mostly about Chapter 7, which is your basic bankruptcy, your basic liquidation. Um, we make all consumer debts or all the person's debts go away. The term art is they are discharged. Um, if they have assets and because of the exemption schedules that we will talk about, at least in general, um, most of my clients don't have any assets, even though they may own a house or a car or have retirement money. But to the extent that they do, those go away as well. I will allude to Chapter 13. I'm not going to touch Chapter 11 today. We'll get there. At any rate, in bankruptcy, we are primarily interested in four things: um, assets, what people have; liabilities, what they owe; income, what they bring in each week or each month; and outgo, what their expenses are. And I know you've been looking at the bankruptcy software, and you can see that schedules A through J uh, basically deal with those things. Um, and the idea behind wanting all this information is that while bankruptcy is extremely powerful, I've had clients where I've made hundreds of thousands of dollars of debt simply go away. It just vanished, frankly, without losing anything. Um, the court wants to know what do you have? Why are you in this mess? Or what is your situation? Certainly, you're not going to have people walking away from huge amounts of debt who are worth a lot of money. Um, so if it turns out that they got cash in the bank, that they've got various investment properties, all have good equity in them, and whatnot, that's a very different situation from from a person who doesn't, who basically is underwater on their house and underwater in their car and doesn't have anything else. So the first phase of the bankruptcy, Schedules A and B, is just simply identifying assets. So typically, what we'll see is that our clients would have their residence, their home. Not all of them, obviously, and not even most of them, but many of them. They probably have a bank account with a little bit of money in it, a car, of course, and hopefully have some retirement money. But we do disclose everything, and this is a one size fits all petition. So I like, for years and years and years, I used to say to clients, if Donald Trump had filed personal bankruptcy, he'd be filing the exact same petition. Uh, my clients are filing the exact same forms. And because it's one size fits all, a lot of the questions can be kind of kind of weird. They ask about pets, and then again, nobody is interested in taking, somebody's, you know, 6-year-old, spayed, mutt. Um, but some people have pets that are worth thousands and thousands of dollars, and that would be a different story. It asks about furniture. And again, I've never had a trustee come in and take somebody's dining room set or somebody's bedroom set. But if you have a house full of Louis XIV antiques, well, that's furniture too, and the trustee might have some interest in that. And so, the first part of it is just to disclose what the client has. And we do want to err on the side of over disclosure, or just make sure that we disclose everything. Again, the bankruptcy is very powerful, and kind of the quid pro quo for asking the court to do all of this wild stuff in terms of making, as I say, large amounts of debt simply disappear, is that you play honest with the court. And really, where people get in trouble in bankruptcy is not for what they do or for what they say, but for what they don't say. Most people who get in trouble in bankruptcy court are in trouble for failure to disclose, for failure to deal honestly with the court. And the interesting thing is, particularly with my clients, is that when we dig in and find out what it is that they're hiding, it's usually something I can deal with anyway. So they're their own worst enemies sometimes. But that's the first thing, is just to make sure that we know what they have, disclose it in the schedules. The next schedule you saw in the software is Schedule C, which has to do with exemptions. And the bankruptcy code allows you to keep a fair amount of stuff. Here in and we're very fortunate here in Massachusetts, and New Hampshire, by the way, works the same way, and I'm licensed there as well, in that in Massachusetts and New Hampshire, we're allowed to choose between the state exemptions and the federal exemptions. In other words, the bankruptcy code itself says how much equity you can keep in a house, how much equity you can keep in a car. It has very generous wild card provisions for especially for renters or people who have little or no equity in a house. But Massachusetts will allow people to keep $500,000 of equity in their home. And we don't see a lot of people coming in here who have over $500,000 of equity in their home. So that basically means that any client we have, for the most part, if they're current on their mortgage, can keep their house. If they're not current on their mortgage, that's where Chapter 13 comes in, because Chapter 13 allows us to reorganize that mortgage arrears over a 3 to 5 year period. And as long as the people now pay their mortgage going forward and pay their plan, which includes the mortgage arrears going forward, they can keep their house, even if I file this thing a minute before the foreclosure auction. And there's actually case law on that, believe it or not, where it really was a matter of timestamps. And the timestamp was very slightly before the auction. And the judge said there was no auction. the automatic stay had issued. So, again, it's a very powerful thing. In fact, let me tell a story on this. I had a case once where I had filed a Chapter 13, and apparently my client's house did go to auction, and a person bought it. Usually it's the bank that buys them at auction, but a real live, honest to goodness person bought my client's house. Only, of course, he did not because I had filed the Chapter 13 petition. And the guy calls me up. I don't know why he's calling me, but he calls me up all upset. The person who bought it, and and I'm telling him he didn't buy it. And he said, yes, it was. I was at auction and I bought the house. I said, there was no auction. He said, what do you mean there was no auction? I was there. You weren't there. There was an auction. I was the high bidder. I gave the auctioneer my $5,000 check. There was an auction and I won it. And I said, yes, but there was an automatic stay in place. There was no auction. He said, what automatic stay? I didn't know anything about an automatic stay. And I said, well, that's why it's automatic. You don't have to know. It stayed anyway. And that auction legally never happened. And hopefully the guy got his $5,000 back. I'm sure he did. But that's how powerful this is. So anyway, going back though to the exemptions, again, if people have paid their mortgage, if they're current on their mortgage and they don't have 500,000 of equity in Massachusetts, they can keep the house, and the trustee in bankruptcy can't touch it. Massachusetts actually has very generous, a reasonably generous exemptions for motor vehicles as well. I believe it keeps ticking up, but I believe it's about $7,500 of equity. And we don't see a lot of cars with a lot of equity. Occasionally an SUV because they hold value pretty well. But most cars have loans on them, so there's little or no equity there. If the loans have been paid off, the cars are generally not worth very much. But certainly, if somebody were to walk in here with a 2021 Lamborghini owned outright, that would be a problem. But again, we don't see a lot of that in bankruptcy. What is and retirement accounts? The other big asset that people do have is their retirement money, their pension, their IRA, their 401k. And for all practical purposes, these are exempt assets. Actually, I've got a story there. I like telling stories. My last job before I went out on my own, so this story has some age on it. But my last job, I worked at one of those law firms that had 4 lawyers and 8 offices, which basically means 7 offices with just a room with a desk in it. And we did a lot of bankruptcy. And every week I would go to the bankruptcy court in Boston and do the trustee hearings. And generally speaking, that was the first time I ever met the client. Somebody else, a few of those clients were mine, but most of them belonged to the other lawyers in the firm. And frankly, when I arrived at the hearing, that was the first time I looked at the file. So there I was, all of 27 years old, so maybe it wasn't that long ago. All of 27 years old, and I've got this guy's deputy fire chief in one of the cities here in Massachusetts, and I'm sitting there with the trustee, and I've never met this guy before in my life, the deputy fire chief, and the trustee, and there's no reference to his pension on the petition. My boss messed that one up. But at any rate, the trustee asked the guy, you're deputy fire chief, don't you have a pension? And said, oh yeah, I've got a great pension, and he's bragging about his pension, which of course is the worst thing to do in bankruptcy. But in any event, the trustee looks at me and he says, counsel, why shouldn't I take this man's pension? And I looked right back at the trustee and I said, let me brief you on that, because I frankly had no idea. I was just starting out in this firm and never really done a lot of bankruptcy. At the time, that was an ambiguous issue. Since then, the Supreme Court has decided it in our favor. It's not an asset of the estate. So we can take very large 401ks through bankruptcy safely. Uh, and then there's the issue of wild cards. The feds have a very good wild card. It's at this point probably about $12,000 or $13,000 a person. In the state of Massachusetts, it's about 6,000. In both cases, and we'll kind of dig into this in a little bit more detail when the time comes. We've got real petitions in front of us. But a wild card exemption is just that. It allows you to protect anything. And the most important thing that it would be protecting is cash. Although Massachusetts, interestingly enough, has a bank exemption and a cash exemption, both of which protect bank accounts, and both of which can be used. There's actually case law on that. Trustee Nicholas challenged somebody trying to use both exemptions, and the bankruptcy court said they're both there. You have to use them both. So that was pretty cute. So for most of our people, really the vast majority of the people who come in here, we can protect everything. Now there are some problems, particularly on the federal side, when you have a house with equity, you don't get such a good wild card exemption. But when we have houses with equity, we tend to be on the state side anyway, because the state's homestead is so generous. One caveat on homesteads: be aware that the person has to have had the house for more than 40 months. I think the 40 months, as opposed to 3 years or 4 years, is just to lay a minefield. It was part of the big bankruptcy reform 15 years ago, where they really did lay out a minefield for attorneys. But if it's been less than 40 months, you have a much smaller cap. I think it's 120,000. However, we very rarely see a lot of equity in a house that hasn't been owned for very long. The reason for this, by the way, was Enron. Do you remember Enron?
I remember reading in school.
Okay. So yeah, all these, Florida has an unlimited bankruptcy exemption, an unlimited homestead exemption. So all of these Enron guys went and bought multi-million-dollar homes in Florida and then filed bankruptcy. And so the 40-month thing was supposed to slow them down, I guess. So I'm not sure how effective that really was, but that was where it came from. Was people trying to do a little bankruptcy planning by sinking all their money into houses and in places which, as I say, have very large, in Florida's case, limitless um, homestead laws. So as I say, that's kind of the good news for us, is that as a general rule, we can protect everybody's assets. On those rare cases where we can't, it's usually something small, like, I have clients who have too many vehicles. You can only use One person can only use one motor vehicle umbrella one time. So if one person has two cars, one of them cannot, you can't put the motor vehicle umbrella over both of them, even if there's enough equity. Uh, but as a general rule, with things like that, you have trustees who are very anxious to play let's make a deal, because they don't want the car, they want the cash. This happens a lot with self-employed people, where they may have some um, business tools, or one guy had scaffolding. I couldn't protect the scaffolding. But believe me, the trustee did not want to come pick up the scaffolding. We had a very easy time making a deal on that. Things like that. But where that can't be done, there's also Chapter 13. Chapter 13 allows people who I like to call asset rich but cash poor to buy out their equity. Back in the day, Massachusetts did not have such a generous homestead exemption. So we would have clients who had equity in their homes that we couldn't protect, and we could just reorganize that equity over a 5-year period in Chapter 13. So occasionally we have to do something um, a little bit different. But for the most part, we do no asset Chapter 7s. Then you have the debt. And this is where the Uniform Commercial Code comes in real handy because for our purposes, there are really three and a half types of debt. That half being student loans, which kind of live in their own world. But we have secured, unsecured, and priority debt. And sometimes it's a little bit challenging to figure out which is which. But unsecured debt, that's the good stuff. That's what bankruptcy was really designed to deal with. That's credit cards, that's personal loans, that's medical debt, that's money owed to a utility or to a landlord who evicted you. That's what you owe after your house has been foreclosed or after your car has been repossessed. And so it is most of what we see. And with very limited exception, it's all dischargeable. Um, there's some problems with recent debt. You're not supposed to go and run up your credit cards one day and come see me the next to file bankruptcy for you. But and things like that. And then there's the problem of co-signers because they of course are left holding the bag if the principal signer uh, discharges the debt in bankruptcy. But for the most part, uh, unsecured debt is dischargeable. The big exception being student loans, which are neither priority debt nor dischargeable most of the time. And again, student loans are kind of their own topic here. In fact, I attended a 2-hour webinar on student loans just last Friday, and that's just a whole messy issue here. Hopefully, Congress will fix it someday. But until then, we'll just put it off to the side. Secured debt has collateral. So the most famous forms of secured debt are mortgages and car loans. Uh, Occasionally, we see it with store credit, jewelry stores in particular, jewelry stores and furniture stores. If somebody buys jewelry with their K's card, uh, they almost certainly collateralize the credit card with the K's account. See in furniture stores, Best Buy is an issue for us sometimes. When I was a young lawyer, Sears used to advertise the softer side of Sears, and I used to love that not because I love Sears or their commercials, but because it helped me to explain store credit. If you bought something from the softer side of Sears, clothing, bedding, draperies, that kind of stuff, and you used your Sears charge, Sears didn't claim a security interest in it. But if you bought a washing machine, tools, anything made out of metal or plastic, Sears probably collateralized the Sears card with the merchandise. Now, fortunately, most of these stores have transitioned over the last decade or so and offer Visas, Masters, American Express. So even though the card is store branded, it's not store credit. It's a regular unsecured debt, just like any other Visa, MasterCard, or American Express is unsecured debt. Um, when you have secured debt, the client basically has a couple of options. One is to discharge the debt and no doubt lose the collateral. So you can walk away from a house, walk away from a car, walk away from any of these things, or keep paying the debt and keep the collateral. So, in fact, with cars in particular, you very rarely give up a car because my clients, generally speaking, want to keep their cars. So as long as they can afford the car loan, they keep their car. And similarly with houses, although we will from time to time uh, give up a house. We did it a lot during the financial crisis, for example, where People had $300,000 mortgages on what had become $150,000 homes. They were, you know, rather, they were happy to walk away. And so the bank gets their collateral to get the house, to get the car, but I like to say we erase the client's signature from the note. Okay, so that I got to stop turning around. So that the client no longer owes the money. So if there's a deficiency, bank loses. So we see a lot of that. Now, where things, by the way, kind of get complicated is when the IRS takes a tax lien, or how we deal with personal property taxes or water and sewer and things like that, because most of those tend to be secured as opposed to priority debt, which I'll talk about next. And again, identifying secured debt can be a little bit tricky. And I don't think right now I want to talk about my form letters, or the old exchange of form letters I used to have with Radio Shack. But we have a similar exchange now with Best Buy, where they say they have a security interest, and I write to them and say, prove it. And sometimes they do, and sometimes they don't. But they're always willing to make a deal when they do. Because again, Best Buy doesn't want their stuff back. They just want some money. The most they're allowed to ask for is what the stuff is now worth. It's funny because we're both staring at this television screen, and I bought it on clearance for $400. I had a client who bought this exact same TV brand new for $1,000. And so I explained to him, Best Buy has a security interest in the thing, but they can't even begin to argue that it's worth any more than $400, because that's what I bought mine for. And of course, you took it home and took it out of the box, which means it's worth even less. Mine now would be worth even less than the 400 that I paid for it. But they're even willing to deal from that lower number, or take payments, because again, they're not in the business of secondhand merchandise. It's just a hostage. We're just negotiating over the hostage, or the value of the hostage. And then there's priority debt. A priority debt is taxes, although we have a lot of rules regarding income tax. If income tax is of a certain age and certain things have been done right, it actually becomes unsecured debt again. But all other taxes, I have clients who, for example, don't have businesses, have employees, and for whatever reason, don't like paying their payroll taxes, which is the worst possible debt you can ever have. And under no circumstances can that ever be discharged in bankruptcy. Um, Alimony and child support is priority debt, not dischargeable in bankruptcy. Um, Actually, on the priority side, that's really what we see a lot of, is those categories. There are things, maintaining bank capital, or wages owed to employees, or money owed to an employee benefit plan, but we really don't see all that much of that. But it's right there. It's on our intake sheet. It's in the petition itself. Does the client have any of this stuff? Money owed to a farmer or to a fisherman. Apparently, they had very good lobbyists, and got themselves exempted from from bankruptcy. Uh, and one of the interesting things about that last point is that as you work in this office and you read the bankruptcy code, you read the Internal Revenue Code, you read the Immigration Nationalities Act, these various federal statutes we deal with, do understand they were all written by politicians. Um, and so, number one, they read incoherently, because a lot of what's in them is just plain stupid. But it's the law, so we deal with it. But part of it is you'll see a lot of things that don't make intuitive sense, but do make sense once you start to think about it in exactly this context, that there may be a political reason rather than an economic reason or a public policy reason as for why something is in the code the way it is. So in any event, hopefully this um, helps give a better understanding. Let me say a few more things, actually. Um, we can discuss the statement of financial affairs later. One of the things that we're not that interested in, though, and it's the thing the client most wants to talk about, is how they got into this mess. I like to tell clients, have you ever been to a parade? And at the end of the parade, you see the guys with the buckets and the shovels and the brooms cleaning up the mess. Well, that's me. I'm just the guy at the end of the parade cleaning up the mess. It's really not my concern what they're feeding the horses. Uh, you know, it's, it's really not for me to say whether it's a good idea or a bad idea to have had elephants in the parade. I'm just cleaning up the mess. And from the trustee's point of view, the bankruptcy court's point of view, really and truly, we're not judging anybody, and we're not granting absolution to anybody. We're just cleaning up the mess. So there's really only one bad answer to how did you get into this predicament. And that one is, well, gee, I thought it'd be great to go run up my credit cards and then file bankruptcy. I felt like ripping off creditors. That will get you in hot water. That's not what we're here to do. We're here to fix. But I got laid off. I got sick. Um, you know, that 2% credit card rate became 20%. I tried to start a business and it failed. I shorted GameStop and had a margin call. That one might cause some interest from the trustee, but we get you through it. But for the most part, you know, it's not really what the case is about. And so, the clients are going to want to tell their story, and within reason, we let them tell their story. Um, but but again, we're not here to judge. We're just here to clean up a mess. And so there we are. So as I say, I hope that this makes it a little bit more coherent. I'm sure you'll have a ton of questions, but we both have people go talk to, and so let's go do that. So thank you.